Beesinger. David Anthony Beesinger. What's your name? Did I already send yours back, ma'am?
Yes.
David Anthony Beesinger, 20B138306.
Good morning, Your Honor. Anthony 1520. On behalf of Mr. Beesinger, who is to my right, speaking to the right.
David Beesinger, Your Honor.
That has to go back to do it.
Both of these?
That one right there. Let me just check something.
Is there any more of his in there?
Yeah, I can't take that. I can't take that. Minor injury report. I just moved it. Sorry.
This one too?
No, that one goes.
This
to
one's good.
Lisa. All right, my apologies. Counsel, your client was sentenced in this case on February 17th of 21. August, he was here. I told him to go to DNA that night for testing and come back on August 19. He did not show up for sentencing. So he's got a problem. Let's call in Elizabeth on this telephone. I mean,
Your Honor, is it the probation violation sentencing or the original sentence?
well, no, it's not it's going to be a probation violation sentence. He pled the failure to submit the testing on June the 14th and June the 26th of 21. That's what whoever's got the phone, who's got the phone? Who's got the phone? Do you have the phone? Sir, do you have the phone?
Me?
Who has the phone out there? It's gone off twice. Get the phone out of the building, please. Folks, if anybody's phone goes off in here that didn't just heed my warning, I will hold you in contempt. So get the phone out of the building unless you want to go to jail. Is that you?
Yes, sir.
Get the phones out of the building, everybody right now, so I don't have to lock somebody up. Somebody's lying to me. I mean, I got only 6 people in the courtroom. The phones are going off and everybody's acting like, so I'm just forewarning everybody. If the phone goes off again, I'm sending you to jail.
Your Honor, we'd be ultimately asking for an adjournment. Mr. Beesinger.
I'm not gonna adjourn this again. No way.
I understand. He's on a probation out of the 25th District Court. I have a letter from his probation officer. He got stopped for this warrant, and as a result of that, they searched his car. They took one of his tools out of his work bag, and they charged him with a new crime. So we're trying to see what goes on with that. I do believe it's inappropriate, but I wanted him to have the opportunity to address that. He has court in this court tomorrow. So he's going to be here tomorrow for that case. I do have a letter from June 9th from his probation officer in 25th District.
Mr. Nahiki, this has been going on for 4 years.
I understand. At the time,
Let your lawyer talk,
he
don't
was
interrupt.
an addict. He
I know, but he-
understands he had issues. He's been clean and
Okay, I get it, yeah.
for 3 years.
Okay. Listen, I'm not adjourning it. Request denied.
No, I'm not about journey.
Good, then don't say anything. I'm going to sentence you on this violation right now,
Okay.
okay? You should have been here. You didn't show up. Judge McNally doesn't like that.
I understand.
Maybe there's more judges somewhere out there that are a little bit more tolerant of it. Good for them.
I understand that.
Okay, you're not going to play with courts and you're not going to ignore courts. I gave you an opportunity back in August of 21 saying go test,
I understand.
and I set the sentence.
I understand.
And then you, what, did he even go testing as well? What's your name?
Elizabeth Ross, probation. No, Your Honor, I believe I marked the file. He did not test, but no, he did not test as part of that order on August 2nd of 2021.
So I'm sorry, I'm not going to adjourn it. I'll listen to whatever anybody has to say.
So the biggest reason I'm asking for that adjournment is he's about to join the union.
I don't care if he's going to join the United States government. I'm not going to adjourn this case, period. Period.
Your Honor.
No. How many times I got to say no?
Yes.
Understood, Your
What would you like to say before I sentence him?
I would ask that the court allow me to read the letter from the probation officer.
Sure, absolutely.
So it's-
Or I'll read it, whatever you want.
It says, Mr. Biesinger is currently under supervision at 25th District Court for OWI impaired offense. He has consistently appeared for court reviews and probation appointments since November 2023. Throughout his probation term, he has attended AA, secured a sponsor, recently entered outpatient substance abuse counseling at the Guidance Center with Joshua McAllister. Mr. Biesinger will be discharged from probation July 24th, 2025. As the court will be losing jurisdiction at that time, please feel free to contact me with any questions or concerns.
He's not in sobriety court, right?
No, I believe it's just a normal probation. His officer is GN Mendenhall.
Is that for the aggravated assault, or is that for the operating while impaired?
Operating while impaired. And he's been on that probation. He's doing therapy 3 times a month. He works 2 full-time jobs. He's about to get into the union at Caden Plating Factory. He's been sober for 3 years. Obviously, at the time, he didn't have everything going for him. I think he does now, and I think really that's the most important thing. Obviously, the goal of his original probation was to get him to the point he's at right now.
Well, the goal was also to make sure
I
he
understand.
did not commit other crimes, and went out and got an impaired and he got an aggravated assault.
Right, I understand that. But at the same time, I do think he's made tremendous strides. And honestly, I think this is somebody that should be given the opportunity to avoid a jail through maybe court work program days. If he doesn't get those done, well, then that falls on him. But he's at a good point in his life. He could drug test today, he could drug test tomorrow. It's not going to be possible. He's clean, he's sober, he's doing the right things. I just don't think it would do him any benefit to be incarcerated. Obviously, the court has the ability to do that, but we're just asking for some grace here. I mean, I think you know Mr. Biesinger. I think the person you knew back then isn't the same person, and I think that does matter. Your Honor.
What did he do, if anything, on this? Can you tell me?
I would love to be able to give him a positive report, but he did not attend any of his court work program days. Just in my last communication with him I won't say complying with his probation, but when he was actually reporting, he still owed all his fines and costs. I scheduled him for the court work program. He did not show for any days on the court work program. I will say he did show me proof that he was employed in June of 2021. As far as treatment's concerned, again, no verification that he completed his treatment at the time he was at the Guidance Center as well. With his chemical testing as the show cause, he didn't go as part of bond, he didn't go as part of probation. And that's in reference to your case, Your Honor. Of course, we have other issues that would contain on Judge Hessen's case, but.
He's got a case in front of her
He
too.
had a case in front of her at the time, that ended in 957, yes, for a substance possession use case.
I can call those with you here. That ended on 957.
No, the case number ends in 957, Your Honor. I'm not sure if you have it on your screen.
Ah. Let's see. Oh, I see. Go to number 13. Oh, has he been sentenced on that yet?
Yes, Your Honor, he was placed on probation.
No, I know, but has he gone back on some kind of a violation since then?
He did not appear. I believe I'd have to check his court date on that one.
Okay. Anything else that you want to say, Ms. Wilds?
Nothing else as far as, Your Honor, as you know, it's over 2 years old. I'll give him credit for being sober, but he's been sober for 3 years, but he didn't have the wherewithal to come in and speak to us in 3 years. Being on probation for 2 years for an OWVI over in 25th. As far as court work program is concerned, again, he didn't do any days. I understand use, I understand non-compliance, but at this point in time, he's not a candidate for anything associated with probation. He's already proven that he can't show to court, he can't show to court work program, probation. I do recommend jail at this point in time. It's been far too long, and he's had a lot of opportunities to rectify this in the proper way.
Anything you want to say, Mr. Deason?
Your Honor, 2019, 2020, 2021, all those years, I was a full-blown heroin addict, okay? I was on heroin for about 8 years. Back in 2023, I had my daughter, Liliana. I got sober. I went to Sacred Heart. I got sober. I worked cement in the morning. I've been working at this factory from 3 to 11 every night. I've been doing wonderful. This is the best I've ever done in my life right now. I completely understand that I should have came in here, took care of this, got back on probation, all those things. I brought it up to Ms. Mendenhall before. Everybody has always told me, take care of it in the future, which that part I completely understand. Now I'm here.
Take care of it in the future?
Yeah, that's what everybody's always
Hang
said.
on, hang, whoa. A probation officer in another court told you, knowing that we had a warrant out for your arrest, to quote, take care of it in the, hey, let me finish. I just want to know who I'm calling over there. I want to know what judge to call. I'm going to figure out who the chief judge is. I want to make sure. A probation officer, Ms. Mendenhall, told you, knowing that you had a warrant out of this court since 21, to quotes, take care of it in the future, period, end quotes. That's what you're telling me.
Yeah.
Okay, I just wanted to be sure before I start making phone calls.
And I see Judge Clifton also every month. I see him, I see Miss Mendenhall.
How do you see Judge Clifton every month?
Because I see Miss Mendenhall and then I go in the courtroom and talk to him about how's my month going and things like that.
Sobriety court?
Yeah.
You're doing drug court?
No, not drug court, but I go see Miss Mendenhall every month, and then right after I see her, I go into the courtroom and talk to Judge Clifton also. He knows about me, he's very proud of me of how much better I'm doing. And this is the best I've ever done right now. I mean, I have 2 jobs, I'm taking care of my daughter every day, I have a car, I'm about to
Hang on
join
a
the
second,
union.
hang on. Are you going into, I just want to be clear about this. Are you going in and sitting down with other sobriety court or drug court participants and talking to the judge? Or are you just going in and having a chat with them because it happens to coincide with the date that you're going in to see your probation officer, and you just want to go and say hi and see what?
No, I'm scheduled once a month to go see the probation officer and then see the judge. So I go see Miss Mendenhall, talk to her for about a half hour, and then I wait for, and I go into the courtroom, and then I talk to Clifton for about a half hour. Not a half hour, about 20 minutes. But I see.
Does anybody else do that?
I don't know.
I mean, I'm just saying, when you're having this conversation, are there other participants in there?
No, it's just me. It's just me that I know that does this.
I can tell you, Ms. Mendenhall, I don't believe is the sobriety court officer over there. I believe, probation officer by the name of Simone Kissinger, I think is her last name. I don't believe Ms. Mendenhall does sobriety court or drug court over there. I could be wrong as far as I'm not employed there, but to the best of my knowledge, she's just traditional probation.
Your Honor, I completely understand about all these violations with probation, but I just want you to realize, like, I was a heroin addict then. Like a few years ago, I was a full-blown heroin addict crackhead living in the streets of Detroit. Like then, I didn't have no responsibilities in my head. I didn't think about coming to do a work program, none of that. I didn't answer to nobody then. Now, going on 3 years of sobriety, I really am a completely different person. I really am.
You went out and committed 2 crimes since you were in front of me. One's aggravated assault, which means you caused a serious injury to someone.
Right, that's when I was.
Let me finish.
Using.
And another one was impaired. Now, it's good that nobody was killed in an impaired action, in the impaired charge. And it's good that you stopped without causing somebody grave injury or serious aggravated injury. I mean, you caused an aggravated injury, which requires somebody either to have a serious injury or at least go get medical treatment. And both of those happened after here.
I understand.
And I'm not buying this that some probation officer told you to take care of that in the future. If they did that, I'd fire them. I would fire them. Who do you think you are, Ms. Probation Officer or Mr. Probation Officer, telling somebody else to take care of a warrant that's out for their arrest sometime in the future when they feel like it, essentially?
I understand. I am a completely different person, Your Honor.
But here's the problem. You might be. But I really don't have any proof of that. I mean, I have a letter that somebody wrote me that told you to go there in the future.
Yeah.
You can't do this.
Your Honor, I could draw for you right now, anything.
Anything else you want to say? Because once I'm done, I'm going to make my ruling, and I don't want to hear any lip. You got it? Do you understand what I just said?
Yeah.
Okay, go ahead,
Your
finish.
Honor, I would just ask again for some sort of requirement in lieu of jail. I know that, it's not a recommendation of probation, but at the same time, I do think, given the fact he's being monitored by another court, given the fact that he's gonna be in this court tomorrow, that he's neither a flight risk, he's not a danger to the public at this point. I think he should be given an opportunity to avoid that jail time through a court work program that was originally ordered. You can order 5 days. 5 days he doesn't do them, he goes to jail. You can say, hey, if you don't do these days, even you miss one, you're going to jail. Set the amount of jail. I'm just asking for some.
Let me see the screening again, Lee.
To give us a chance to avoid that and keep on the right track like he is right now.
Your pet, Ted. Does he have any credit coming on this, Ted, Beth, to your knowledge?
Not to my knowledge. Again, no days completed on the court work program. I will definitely look and see on the ROA if there was any credit at the time of his arrest or detainment. And it looks like you gave him credit 1 day for any detainment of police. But again, the 5 days that he was to do in lieu of serving jail, he did not complete.
Anything else? You've said everything, but I just want to make sure I've let everybody speak.
Just that I'm very proud of myself right now at the end of the day. You know, like if I wouldn't have wanted to deal with this, Your Honor, I wouldn't have came this morning. You know, I got up early, 7 o'clock in the morning, sharp, got here. I joined the union next week.
You were in custody June 2nd.
June 2nd.
Right? Weren't you
I just did 2 days when they pulled me over 2 weekends ago
So
over
you
the
were
case in 2019. So I did 2 nights. Saturday night, Sunday night, bonded out for 500, Monday, and made it to work by 3. So at least I got out and got my car back.
Probation's revoked. You're to pay costs of $1,000 and serve 90 days, credit 1 for 89. If you pay costs of 1,000, I'll suspend 59 of the 89. You only have to serve 30. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. So you're going to serve 30 days. You've got a bond of $250. I don't know whose name it's in. I gotta go to
jail.
What did you think? Have a seat. I'm not gonna argue with you. You understand what I'm saying to you, son? Should have been 90. Good luck. Have a seat. People against Walker, Christopher Raymond Walker, 25W727443. Your name?
Christopher Raymond Walker. Love you to his brother.
All right, Mr. Walker.
Good. I will need to give him back to Jeremy.
Your name, sir?
Christopher Raymond Walker.
All right, so I am bringing him, entered a not guilty plea. He has one prior violation on April 14th, which concerns me because he was placed on probation in February. How's he going to proceed on this?
Your Honor, ultimately, it is going to be a plea. Like last time, we are asking for an adjournment The reason being that Mr. Walker is seeing a psychiatrist in 2 days to get a Vivitrol shot, which is gonna help him with his alcohol cravings. And we really wanna make sure he gets that prior to the court imposing any sort of sentence. We're happy to take a plea today, set it for a sentencing.
Well, if you want to take a plea, you can take a plea. I doubt I'm going to adjourn it, okay? But, so, that's it, or else we can have a hearing.
I would say that we take a plea.
All right, sir, if you plead guilty, this would be a second violation. You could get 10 days. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
Excuse me, if you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right, to the charge that you failed to refrain from consuming alcohol, testing positive May 19th of 25, how do you plead?
Am I able to speak for myself for a second?
I just need to know how you plead first.
I plead guilty.
Did you consume alcohol within the 3 days preceding that test?
I have a problem.
Anybody force you to plead guilty?
No.
Call in Beth. I'll accept the plea. I find it to be an accurate plea, made voluntarily and understandingly. So he's going to get Vivitrol in a couple of days?
I'm also going to IOP 3 days a week now. I did it myself. So I stopped, I was going to group once a week. I started going to IOP 3 times a week for 3 hours every single week because I know I have a problem, and it's not just, I know I have a domestic violence charge, but before that, I'm not a violent person. I've been going to my anger management stuff and doing everything that I'm supposed to do. I have a problem, and my family knows about it now. They're talking to me. I didn't talk to my family before. I'm finally opening up about it. I'm figuring out who I am. It's an issue. And I talked to my therapist about it, and he said, yeah, you have a problem. We need to get you somewhere.
Okay.
So I'm trying to figure out how to deal with it. It's just very difficult. It's just probation got in the way with all this other stuff, and I didn't know how to take care of it. And now that I'm kind of figuring out how to voice myself, it's been a lot easier, I guess you could say, to figure it out, but it still is an issue, and I'm just trying to get help. And that's what I'm doing. I'm taking steps towards becoming a better man and taking care of myself as well as my kids as well, but it's a long road. It's gonna take me time.
All right. You get a hold of Beth.
She was down here, Judge. I told her. She's on her way.
All right. Did you do the, have you started the domestic violence program?
Like the anger management thing? Yeah, yes.
How far along are you in that?
I think I only have 1 day left or 2 days left.
All right.
Yeah, I've already started that. I've been doing that. The lady's name is Katie. She's an amazing person. I love going to it and talking to people because everybody in there has different stories. So it's nice to just talk to people and see how everybody else has different stories about, their domestic violence, what they did. And I'm like, I'm not that bad. I really am. I'm not an angry person. It was just alcohol that did it to me. Because the night that I got the domestic violence charge was because I was drunk.
Well, I dispute that. Beth,
Elizabeth Prosecution.
in other words, that's not a justification.
No, it's not.
Not an excuse, but can be a factor.
All right. What do you have to say, Ms. Wilds?
Yeah, as far as his use, I wish I could have positive things about Mr. Walker in regards to his use. I just got lab results from his next chemical test. I violated him for the May test. He was positive, confirmed positive ETG and ETS on June 4th as well, Your Honor. I think Mr. Walker has a much bigger problem than he's even willing to acknowledge. He might say he has a problem with alcohol, but the fact that there's continued use, even on surprise tests for him, it's a huge concern of mine. To his credit, he did start IOP. He is attending IOP with the Guidance Center. He shows up for his visits. He is polite. He again, goes through all the motions, but I think this issue with alcohol is a much bigger brick wall than I think even he realizes at this point in time, Your Honor. And it's very concerning that his testing essentially is all positive for alcohol.
I do think he recognizes that, and that's why he's seeing psychiatrists to get the physical shot. So
Okay.
I'm sure.
and that's in 2 days, Your Honor. So if jail's a possibility, I really would be asking for an adjournment until 6/22. I'll be here. Just allow him to get that, and then if the court wants to sentence him to jail, sentence him to jail on that day. But I do think that's the most important thing.
Well, we're gonna make sure he's not gonna drink again. 2 days court work program, pay $35 a day for that. He's to test,
Weekly?
let me finish.
Sorry.
He's to test weekly until October 1st, bi-weekly until February 1st, then monthly. He's to be on a SoberLink device by the end of the day until September the 30th. So you owe $75 plus 70 for the court work program. You're doing 2 days. You're gonna test weekly until October 1, bi-weekly until February 1 if you're clean, and then monthly. One more time, you're going to jail. Do you understand me?
Yes, sir.
Do you have the money to pay this? $145.
Not today.
Pay by June 27th. Can you do that?
Yes, sir.
You have to get the SoberLink device by the end of the day. They'll explain it.
Okay.
All right, good luck to you. Go get Daryl Leslie Wilson. 20F233084.
Attorney
Yeah.
Corey Westmoreland appearing on behalf of Mr. Wilson.
Where's Mr. Wilson at?
The Wayne County Jail.
Your name, sir?
Darrell Leslie Wilson.
All right, so defendant, let's just check here for 1 second. I just want to double check one thing. He didn't appear for this show cause that he was supposed to be here for. I'm sorry?
No, July 22nd, sir.
Just let me finish, will you?
Yes, sir.
On July 22nd of 24,
Right. I didn't know.
23. So it looks like he pled Mr. Westmoreland to all of these. Failure to report on January 19 of 23 and January 27. Failure to schedule and attend court work program days. Failure to pay fines and costs as ordered. Failure to submit to twice monthly chemical testing. Failure to provide verification of attending and completing outpatient, and failure to declare all warrants. So that's where we are with this. He's just awaiting sentencing. What would you like to say?
Yes, Your Honor. My client.
In on this?
That is her case, yes.
Yeah, I need her. Can you tell her? Go ahead.
Your Honor, I would like you to know that Mr. Wilson just served 30 days in Oakland County Jail. He now is in the Wayne County Jail where he's awaiting a tether. I would simply just be asking for credit for time served on his behalf. At the time, he was going through a very, very rough patch, as you can imagine. His father had just recently passed away. It had kind of sent him into a spiral, and he's finally picked himself out of it, and he's working hard to ensure that he never puts himself in this position again. Again, Your Honor, I'd simply just be asking for consideration for credit for time served, and hopefully you will never see Mr. Wilson again.
So you're still at it, huh? Still at it? How much does he owe, Lisa? Ms. Wild's your name?
Elizabeth Probation, Your Honor.
I'm second, Judge.
You want to say anything, Mr. Wilson?
I had to keep muting him because of the background noise.
Oh, that's okay. You can unmute him now, right? You have to unmute, sir. There you go. Any,
Your Honor, I thank you for giving me the opportunity to see you this morning, and I do have something to say. Your
Okay.
Honor, back when, like you said, last year my father had died, but at that time, sir, I was coming out of just finishing a sentence at Oakland County Jail where I served 180 days. If you ought to have a possession of some plea by mails, where I was just hoping to just clear all of this out. I have completed a residential treatment, an intensive IOP2 and an intensive IOP1, as well as aftercare. I'm now 1 year clean, Your Honor. I have not paid anything in restitution, Your Honor, but I am on my way to doing better. I'm getting myself together, Your Honor. This case right here, it's a disagreement between me and my wife. And so I'm waiting on a tether right now, but I'm hoping that we can resolve this so I can put this matter behind me, Your Honor. I'm doing much better. The only thing that I haven't been successful at is finding a job, and that's just because of just my circumstances. But I have been doing vocational training, so I'm working to get myself together so I can put myself in a better position for myself and my family, Your Honor.
I don't see any plea by mails in here.
I sent 2 of them. I was in jail. I was incarcerated from August 2023 to February 2024.
Here's one January the 11th of 24 we received on the 18th.
Yes, sir. Those are the ones I'm referring to, Your Honor.
And that's when I went ahead and sent. You're supposed to appear here in person in July of 24. Why didn't you do that?
Right. That's the one I was referring to when my father had passed away. Judge Brennan was courteous, and she was generous enough to give me a personal bond that day. The funeral was on the 21st. And the court date was on the 22nd, you know, just dealing with family. And I mean, I didn't have transportation at the time, Your Honor, and having to depend on someone, and they were still consoling one another. I couldn't make it down here, Your Honor. I live in Grosse Pointe, Michigan. So it was just a significant problem for me to get there. Otherwise, I really would have made it, Your Honor. And I tried my best to make arrangements, and I have no excuse, to be honest. I just didn't come, you know, and I don't want to put myself in a position where I'm making excuses, because I'm not. You know, like I said, I take responsibility for my actions, and Judge Brennan was nice enough to give me a personal bond, and she understood my situation, but I tried everything I could. I just could not make it, sir. Public transportation would have got me as close as Southgate, and that would have been a hell of a walk to get to your judge, you know, to get there, but that was the only other option.
If I'd have told you I had $5,000 to give you if you got here, you would have gotten here. And listen, my condolences on your father, really. But you could have come in August, September. Don't give me this, okay, please?
Yes, sir.
I really don't want to hear it. I just don't.
Yes, sir.
I mean, you didn't show up. You got warrants all over the place here.
I have no warrants now. Everything is cleared up at this point right now, Your Honor. Everything is cleared up.
What do you have to
All of
say?
Yes, Your Honor, Elizabeth Wells, probation. Mr. Wilson didn't show for his instructional appointment, so I unfortunately don't have any type of update or any kind of credit that I can give Mr. Wilson. He absconded essentially right after his sentencing. I'm not seeing any days credit on the C case, but on the B case, it was written 18 days credit with 72 being deferred, Your Honor.
I'm
seeing on the ROA, the 20F 233084B. 18 days credit are listed in the jail days section.
Is that on B or C?
On the B case, Your Honor, on the ROA on the cardboard. But other than that, I can't offer any kind of insight. It appears Mr. Wilson's in custody on a separate case. That's why he's present, you know, obviously in court today. And he's past his 2 years at this point.
I don't know what.
And I do want to also admit, Your Honor, that I have just completed 2 probations, one in Detroit and one in Oakland County. I have been on Oakland County probation for the past 3 years, Your Honor. That's what it's also make it complicated. I was on 3 probations at the same time. I completed in Oakland just this past Friday, where I just paid $8,000. I just paid $8,000. It was all I had, Your Honor, just to get off of Oakland County probation and completed the time allotted. And the Detroit probation, that one was dismissed as well, Your Honor. So it's not like I haven't been doing anything or reporting to anyone. It's just that, I mean, and I don't mean to disrespect your court or your probation officer at all, but it was literally just the farthest and the hardest to get to. And I had to at least put some sort of effort into completing at least one of them. So I did what I could with the two that I had down here that I could reach. And that's just me being honest, Your Honor. I really do apologize, probation officer. Like I said, it definitely wasn't anything personal, but it was just what I could do with what I had to do. Like I said, in the past 2 years, I haven't picked up any new cases. But this one right here is just a disagreement between me and my wife, and it ought to be resolved next Monday. I knew that you guys would consider picking me up, so I had tried to make arrangements to collect some sort of money, but I have nothing, Your Honor. I had to borrow like $2,000 from my mom last week, and I depleted my savings, so I don't have anything.
All right. You wouldn't have to spend time in jail if you didn't keep getting yourself in trouble. You blew the court off. I like giving people chances, but not when they blow the courts off. And you blew us off. Okay? I don't know why people do that. I don't understand it. They can give all the excuses they want. They were addicted. They didn't have a ride. They forgot. I mean, I could go on and on. I could go on for 20 minutes of excuses I've heard over the last decades. The fact is that it just isn't high on your priority list. And the fact is, you weren't going to show up unless you were picked up on something else either. So you got to make wiser decisions, Mr. Wilson. I'm sending you back to Judge Hessen on her case. On this case here, I'm revoking your probation. You're to pay costs of $625 and serve 90 days, credit 18 for 72. If you pay costs of $625, I'll suspend 37 of the 72, and you'll only have to serve 35. That is a gift. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. You're going to Judge Hessen on that disorderly case. It sounds like you owe a lot more money on that. You'll have to talk to her, okay?
Disorderly?
Judge, that's your case. It's a BC.
See, that case doesn't even belong to me. I didn't.
Why did she sentence you then? Okay, my mistake. It did look like, all right, she sentenced him for some reason. That's fine.
Looks like at some point she may have arraigned him on a warrant.
I did not pick up a new case. I'm confused.
Okay?
Okay.
I got files all over the place here, Lisa. Thanks for keeping me on track. This was both from the offense date of August 6th of 20. They were concurrent. It looks like she would have taken the pleas on those, didn't she, Lisa? In July? Yeah, guilty plea. So they moved the sentence. So I'm going to sentence him in this other one too. So it looks like on the probation violation that applies to both the B and the C cases, she took them both, all those pleas back in July of 24. I'll just give me 1 second. July 16th of 24. So she took those pleas. She just marked them on one. So on the other one, Probation's revoked, you owe 1314, you pay costs, I'll reduce those to 500 and serve 90 days, credit 18 for 72. If you pay costs of 500, I'll suspend 37 of the 72. You'll only have to serve 35. These will run concurrent. So you have your choice. If you do pay 1125, you're going to be out in 35 days. If you don't pay 1125, you're going to have to serve 72. Good luck. Wish you well. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I really wish you well, sir. I hope you get your life in order. Thank you very much.
Thank you.
Thank you, Judge.
Thank you, Judge.
Brandon Mitchell Kolk. Mr. Kolk, your name? Good morning, deputy, or afternoon, I guess it is now.
Good morning. He was over here eating. I'm about to tell him to come up right now, Judge McNally.
Thank you very much.
Yeah. Come on, Cole. Hey, waiting for you.
Morning, Mr. Kolk, or afternoon, your name?
Mr. Kolk, and good afternoon, Your Honor.
All right, so defendant I took his plea back in September of 13. I sentenced him September 27 of 23. September of 23. September of 23. I took his plea on September 13 of 23. Sentenced him September 27 of 23. I think I was trying to get him into sobriety court, but that is unclear to me. But I ultimately swore out bond violations in November of 23, failure to appear for status review, positive for methamphetamine, failure to appear for chemical testing, failure to appear for probation appointment. I found he violated the bond, revoked his release, forfeited his bond, set a bond violation hearing. Ultimately, and that was in November of 23, and then I ordered an updated PSI in March of 25. He didn't bother showing up for his sentencing on
I think he was in custody.
April 14th, he was in custody.
Yeah, I think it took a minute to figure it out.
Okay. And then that's where we are, but I did order the updated PSI. So I don't know what to tell him. Is he in there just on this, or he's in on other things?
He has another case. He's been incarcerated since April 2025. And he just resolved the circuit court case where he's going to be going to rehab inpatient at Team Jefferson for 3 to 6 months. He's currently waiting on a bed.
All right.
We would be pleading guilty to the probation violation. I'd be asking for time served. He has been incarcerated since April 12th. And then I can address the sentence.
Wait a second here. Yeah, I see. Let me just check something here. See, I never sentenced him on the probation violation. And the probation violation was that he was positive, he failed to appear for court work, positive for meth, positive for MDMA,
And that's when we must have put him on sobriety court bond conditions, because I.
and then he didn't do anything.
Yeah, because I have that signed November 13th, 2023.
Well, I tried to help you. All right, what do you want to say?
I'd just be asking for time served on the violation, Your Honor. He has been incarcerated since April as well.
On some other case, right?
Yes, but I do think that warrant was in place on this case since 2023, right?
No, he did come in to fill out.
March 19th, he was here, I gave him a personal bond.
Okay. I could just ask the court to take some of that time.
I understand. What do you think?
I mean, I know that Mr. Polk has a severe substance abuse issue. He did come in to fill out his screening. He had reported to me at that time that he was supposed to go to an inpatient program. I put that in the screening. I never received proof if he went or if he got picked up before then. I think if he actually does, have an opportunity to go to inpatient, that is going to be his best bet, but with how much time he has left, I don't know how much we can do for him at this point.
I'm not willing to take another chance on him. Just not. I mean, I tried to get him help. I tried to get him into sobriety court.
No, yeah, we completely agree and understand. We're just asking that he's not sitting there longer because he's currently waiting for a bed at Team Jefferson. He's gonna be inpatient for 3 to 6 months.
Could we adjourn the sentencing to see if he actually goes? Does that happen?
Let's go. Oh, boy.
I did look it up on Wayne County and there's not much information. It just says he was sentenced on it was a felony probation violation, but it doesn't tell like what he was sentenced to.
Lisa, how long has he been there? Can you tell me?
I can look it up. Give me 1 second.
I looked it up this morning.
So he must have picked up another case though, because I gave him a personal bond in March, right?
Well, it said a felony probation violation was what he was sentenced under. So he could have been in good standing when you saw him last and then violated the felony probation.
That's what I mean,
That's
sir.
what I'm assuming happened.
He was booked April 11th.
And that was for,
That I cannot tell.
Yeah, and it just said felony probation violation.
Yeah. Sometimes feel like people just do not give me a choice, you know that? 200 fines, 300 costs. No. Mr. Kolk, anything you'd like to say?
Yes, Your Honor. I'm not going to say much because I don't want to say something to upset the courts or anything like that, but I was incarcerated on a probation violation on the 11th or 12th. I was on my way to the area to come to court on the 14th or 15th, but I can't come to court if I'm incarcerated unless they Zoom meeting, which my mom got a hold of the courts too and said that.
Well, I'm not going to hold that against you. I want to be clear about that.
Okay.
In custody. I get it. I get it. So you don't need to worry about that.
Okay.
All right, but continue.
I've been clean as of today since March 10th off of fentanyl and meth for now 90 days. And they just sentenced me on Wednesday to Team Jefferson for rehab extensive treatment, which includes anger management, inpatient treatment, vocational programming, and I'm not going to be able to leave till I complete it, which will be max 180 days. That's all, Your Honor.
How much does he owe on this case? That's. Yeah, I see it. It's $1,000, right? 3526A.
And I haven't been able to pay because I've been trying to get a job. I've been filling out job applications, but it's been unsuccessful. I didn't realize catching an assault with a deadly weapon would make everything really, really difficult to get a job. No excuse though, but I've been actively pursuing jobs.
I don't know why you didn't show up here though for 2 years. I hate that. Especially after what we tried to do for you.
I was incarcerated from November 27th, 2023 till September 10th of 2024 in Wayne County Jail because I caught a case and a bunch of cases, and then there was a global resolution for that, and yeah.
Probation's revoked, pay costs of 1,000, serve for 50 days, credit 1 for 49. If you pay 1,000, I'll suspend 28. 28 of the 49, and you'll only have to serve 21. That's the best I'm gonna do. I hope you can come up with 1,000. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. I wish you well, I really do. Good luck. I hope you straighten your life out. I wish you would have let us help you. Thank you.
You're welcome. Is it ran concurrent, Your Honor? Sorry, I apologize.
What's sentencing?
PSI.
Well, I just ordered an updated PSI. I'm just sentencing on the probation violation is all I'm doing.
Understood.
I just wanted to know what he's been up to since then.
Understood.
Okay? Thanks a lot. Do I have any more with you today? Thank you very much. Good to see you, Mr. Nahikian. We'll talk next week. How are you? Good. Good to see you.
I have good news.
We are back after a weekend at Mackinac Island, which is about as good as it gets. It was beautiful there. Sunny and 70, if you like that kind of thing. A lot of old close friends. It was very nice time away. Now it's back to work. Judge Pattison is off this week, so we've got some double duty. We'll be very busy today. We have arraignments, pre-exam conferences, prelims, including Mr. Karan Fuller and what could be a very unpleasant criminal sexual conduct case. So we've got our work cut out for us, plus a number of pretrials, plus a big pile of stuff to sign, plus more technical problems as the Kramer box isn't working like it usually isn't. So it's good to be back. It is still not quite summer in Michigan yet. Miss Jackson is here. She's already working on some of our clients. I do have a couple more trips to Mackinac Island scheduled before the summer is over, which I've never done that before. 3 times in 1 year, but it's kind of become a victim of its own success. Very crowded. Good morning, Mr. George. But where we go, we kind of stay away from the people. I broke my bike all over, and boy, am I out of shape. Uphill at Mackinac Island. All right, as I said, we got a busy day. Man, that's good. Makes the day go faster. Even though my stupid recording thing doesn't work. Every time I go away for a day or two, it goes wacky. All right, let's go on the record. Anyway, this is the time and date set for a preliminary examination on the matter of People versus Karan Duvar Fuller. That's you, sir?
Yes, sir, John.
Mr. Fuller is here today, and the allegation alleges that in this case number, which is 25760FY on March 24th, that the defendant did possess ammunition by a prohibited person. That is a felony. It's punishable by up to 5 years imprisonment and up to $5,000 fine, mandatory forfeiture of the weapon or device. It's a fourth habitual offender, which I think would be a life offense. Anyway, the defendant is here with his lawyer, Mr. Ross Truckee. Prosecuting attorney Deborah Davis is here on behalf of the people. After several specific attempts, it was clear the defendant wishes to have his preliminary examination. This is the time and date for that. Prosecutor Davis, are you ready to proceed?
Yes, Your Honor.
Mr. Truckee, are you ready?
Yes.
All right. Deborah, you wish to make any opening statement or just go right to your first witness?
Your Honor, I do want to bring to the court's attention that there are allegations of bond violations.
Yeah, there's a bunch of them. We'll finish the prelim and then we'll address all of that stuff
Sure.
left over.
The people will call Deputy Jason Van Dyken.
All right, thank you. Good afternoon. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
Thank you. Please have a seat and state your first and last name for the record.
Jason Van Dyken, VanDyken.
Thank you. Ms. Davis?
Yeah. Deputy Van Dyken, where are you employed?
St. Joseph County Sheriff's Office.
And you've been a deputy there for how long?
Over 3 years.
Were you on duty in St. Joseph County on March 24th of 2025?
Yes, ma'am.
And on that date, did you have some contact with a Karan Fuller?
Yes, ma'am.
And is the person that you believe to be Karan Fuller here in the courtroom today?
Yes, ma'am.
And would you point him out or describe him for the record,
He
please?
is the black male sitting to my left with a checkered red and blue collared shirt on.
Your Honor, may the record reflect he's identified the defendant.
Yes, it may.
Have you had prior contacts with Mr. Fuller?
Yes, ma'am.
And on this date of March 24th, can you explain to the court how you came into contact with Karan Fuller?
So while on patrol in the area of Burr Oak Street here in the village of Centerville, I passed by 234 West Burr Oak, which was the residence to where I know that Mr. Fuller resides. I originally observed him walking towards a motorcycle that was parked on the property. I know from several recent previous contacts with Mr. Fuller that he's not possessed a motorcycle's endorsement. So I waited in the area for him to leave on the motorcycle. That did not happen. Then a vehicle that left and that I observed in the area passed by me. I pulled a traffic stop on that vehicle for obstruction of vision.
So the traffic stop that you had, that was for a different subject that was driving?
Unknown who was driving at the time that I initiated my emergency lights, but it was unrelated to my initial observations.
What time of day was this?
In the early evening, Your Honor.
Thanks.
So with this traffic stop, what did you observe of Mr. Fuller?
He was observed to be the front seat passenger in this vehicle.
And explain to the court what happened next.
If I recall correctly, I made contact with driver Mark Baker, and then other assisting deputies arrived on scene. And from my recollection of the incident was Deputy Raymond, who arrived after myself, stepped out of his patrol vehicle and made contact with Mr. Fuller, who was exiting the vehicle, and engaged in verbal dialogue with Deputy Raymond.
As a result of the contact with Mr. Fuller, was there any evidence of a crime that was being committed?
Yes, ma'am.
Can you explain to the court what that is?
After I had completed my contact with Mr. Baker, Deputy Raymond advised me that Mr. Fuller had exited the vehicle with a handbag or some sort of carrying bag that was on his person, and opened it and presented it towards Deputy Raymond. And Deputy Raymond was able to visually look into and observe shotgun shells inside of that bag. And then Deputy Raymond notified me of this, being the officer who was conducting the traffic stop at this time.
And did you then search this handbag or pouch?
I don't recall, but I do remember that there was one shotgun shell that had already been previously seized or witnessed, but then I did remove one as well off of Mr. Fuller's person.
And explain where that was found.
I believe it was in a coat pocket of a motorcycle jacket that he was wearing, or a jacket that he was wearing.
And these shotgun shells, can you describe them to the court?
It would be brass or steel color, generally is a shot made up of the shotgun shell for the where the primer is stored, and then they come in multiple different colors that are plastic that contain the actual shot or load inside of it. These specific ones being yellow in color, 20 gauge, not a caliber, but a gauge is what a shotgun is chambered in. It was a 20 gauge yellow unspent shotgun shell.
And what do you know of Mr. Fuller's criminal history?
I had a recent previous contact to this date where Mr. Fuller had fled from myself and Sergeant Hernandez. And throughout that involvement and incident, he was located with a firearm on his person. And based off of that incident and his CCH that was ran at that time, that familiarized me further that he is a felon based off of his criminal history.
And to your knowledge, had he been restored his rights to possess ammunition or firearms?
No, ma'am.
And so just to clarify, this traffic stop in the location where you saw him was in the village of Centerville?
Yes, ma'am.
And that's in St. Joseph County, Michigan?
Yes, ma'am.
Did Mr. Fuller make any statements about the shotgun shells that were?
He admitted to me to being in possession of them, but his intent that he had attempted to describe to me of his possession was that he was cleaning up the backyard at the residence to where he resides and was attempting to clean up the backyard and or discard of them later on. Mr. Fuller and I then had a conversation about intent compared to what possession is. If you intended to clean something up, you would pick it up and then immediately discard it in a trash can or otherwise. But the possession would be you pick it up and continue to carry it past the point of when you find an item.
And so it's your belief that he knowingly possessed?
Yes, ma'am.
This ammunition? And the particular ammunition that he had, is that something that could be in its current state propelled from a firearm by an explosive?
Yes.
If I have any further questions?
Good afternoon, Deputy.
Good afternoon, sir.
So you were patrolling in Centerville, you drive past Karan's house?
Yes, sir.
You saw him walking toward a motorcycle?
Yes, sir.
What was on the other side of the motorcycle?
What's that?
Said what was on the other side of the motorcycle?
I don't recall. There are normally cars parked in the driveway as well.
Probably a sidewalk at some point too,
In front of the house, yes.
and a road,
Yes.
you know, the rest of the country.
Village, yes.
Okay, so you saw Karan walking in his yard.
Okay.
Is that accurate?
Yes.
Where did you set up to try to catch him if you left on the bike?
To the east of his house,
Was it an alley, a roadway,
parking lot.
parking lot? Said, what parking lot's that attached to? The courts, the funeral home?
It's a public parking lot just east of his house.
Okay.
I'd have to physically look at the street to identify exactly where that would be.
And you see a vehicle traveling. Did it travel past you?
No.
No. Where did it travel?
It traveled northbound on Jane Street.
Northbound on Jane Street. How far was that from your parked vehicle?
I don't recall.
Close enough to see a face?
No.
No. How long between seeing the vehicle and how long did it take to begin your pursuit once you saw this vehicle?
Pursuit?
Or your engagement with the vehicle?
Several minutes passed by from the time that I had originally passed by the house. I traveled by, circled around the area, and then parked my patrol vehicle.
Okay, was it light out or dark out?
It was light out.
And it was late afternoon, early evening?
Towards the end of my shift, being 6 p.m.
Okay. So you initiated a traffic stop on a vehicle with unknown occupants, is that accurate?
Yes, sir.
And describe just what happened.
Initiated a traffic stop, called out to dispatch the information and activated my emergency lights.
Did the vehicle promptly come to a stop?
The vehicle did not promptly come to a stop. It executed a left-hand turn into the alleyway between Main and Baroque off of Jane Street to the west.
How much ground would you say it covered?
An approximation, maybe 40 yards in total, maybe give or take.
Okay. When a vehicle finally came to a stop, where was that in relation to Karan's house?
Towards the dead end of the alleyway, which is directly or in the area behind Mr. Fuller's residence.
Okay, is that an area you know him to park his car, things like that?
I don't know where Mr. Fuller parks his vehicle at.
Okay. So you engaged with Mr. Baker, the driver of the vehicle, immediately upon stopping it?
Yes, I exited my patrol vehicle, made contact with the driver.
Did you ask for his license, things of that nature?
Yes.
Okay. How many other officers were on their way out, do you know? Two. Is that typical of a traffic stop?
Oh, yeah, I work pretty closely with the other deputies on my shift.
Okay. So 3 total officers, 3 total squad cars?
3 total deputies, 3 total squad cars, yes.
Okay. And that's typical for any traffic stop you were to make?
That's not uncommon based off my training and experience.
Okay.
If I'm generally nearby one of my coworkers that initiates a traffic stop, it's not unlikely or uncommon that I respond out there, even if they're not asking for assistance.
Just, hey, come on out in case things get
It's
weird.
just a general courtesy.
Gotcha. So Mr. Baker, was he able to provide you with a license?
No, he does not have a driver's license, is what he informed me at the time of my contact with him.
Okay, did you run Mr. Baker through your computer system?
I did.
Okay, and it came back telling you what?
I don't recall, but I know for a fact that he had stated openly to me that he did not have a driver's license on him at the time of me contacting him at the driver's window.
Okay, what time did you engage in contact with Mr. Fuller?
It'd be sometime after I stepped away from the driver's window and after other deputies had already made contact with him while I was looking at Mr. Baker's NCIC or lien return as well as the Secretary of State return on my computer.
Could you tell me again why you initiated this traffic stop?
So the original reason for me being in the area again was in reference to Mr. Fuller approaching the motorcycle. After Mr. Fuller obviously did not pass by my location on said motorcycle, I gave up my efforts in looking for him, and this vehicle had piqued my interest just as I was in the same time and place as it was traveling down the road.
And who is Mr. Mark Baker to Mr. Fuller?
I believe he would be the father to his current girlfriend.
Did you know that at the time?
But I know what at the time.
That Mark Baker was the father of Karan's girlfriend?
No.
Okay. You didn't know anything about, who owns this house Karan was living at?
I don't know who's the owner or renter of the house. I know that they live there, but I don't know who physically owns the house.
Did you know you know who lives there?
Yes.
Who do you know that lives there?
Mark Baker and Karan Fuller lived there, but you asked if I know who owned the house. I don't know who owns the house.
That's fair, deputy. So when did you become aware that Mark Baker lived in the same house as Karan Fuller?
I'd have to put that together after I'd seen Mark there several times and Karan there as well. I don't know if at the time if Karan was physically staying there on and off or if that was his permanent residence. I've known Karan to stay at several different places throughout my time knowing him or being around him in law enforcement.
Before March 24th of 2025? You believed Karan Fuller to live at 324 West Baroque, correct?
I know for him to have stayed there.
To regularly occupy that place.
We can say that.
Okay. And you also knew that other people regularly occupied 324 West Baroque, is that correct?
Yes.
And those people are who?
Mark Baker and his daughter,
Okay.
her stepdaughter.
Before March 24th, 2025, did you know what kind of vehicle Mark Baker drove?
No.
No. Had you ever surveilled this house at all relating to
Senate
Mr.?
objection. I'm not seeing where the relevance of any of this is for probable cause purposes.
Where are you headed, Mr.?
I'm headed to this was a pretextual stop. Lacking actual probable cause.
All right, well, that is a slippery slope because it may apply to the driver. And did Mr. Baker get a citation? Did he get a ticket?
No, Your Honor.
I guess-
All right.
Can I clarify with that, Your Honor?
Yes.
He didn't receive a citation, but was there a criminal?
Yes, Mr.
complaint?
Baker was charged for the possession of methamphetamine at the conclusion of his stops. Your Honor.
Okay, so there was I guess I asked the wrong question. So Mr. Baker was arrested on a methamphetamine, well, no. A warrant was issued for Mr. Baker on a drug charge,
The charges were sent off to the courts, Your Honor, for review.
but he was not issued a traffic citation.
No, Your Honor.
All right. Okay, all right, I'll let you go a little further. We'll see where we're headed here.
I believe my question was, had you ever surveilled this house in relation to Mr. Fuller previously?
Actively surveilled it? No.
Did you passively surveil it?
I work in Centerville. I pass by a lot of houses every day, so.
And again, why did you initiate the traffic stop?
As I had stated previously, the motorcycle with Mr. Fuller riding it did not pass by. I was concluding my efforts in investigating him riding a motorcycle without an endorsement. I observed a vehicle in that area that now piqued my interest, realizing that Mr. Fuller is not going to be leaving on a motorcycle or went back inside or went upon his day. So I executed a traffic stop on the other vehicle.
I don't have anything else. Thank you.
Can you describe the other shell?
It was similar to the yellow. They were both yellow, Your Honor.
Were they the same brand and model?
I can't recall that, but they were both 20 gauge shotgun shells, yellow in color, Your Honor.
All right, I don't have any other questions. Anybody else? All right, Deputy Van Dyken, you can step down.
Thank you.
Ms. Davis, anything further?
No, Your Honor, I don't think that we need to have any further testimony.
Mr. Truckee, you have anything further?
No evidence.
All right, argument, Ms. Davis?
Your Honor, the testimony provided by Deputy Van Dyken shows that this individual, Karan Fuller, who the deputy had knowledge of and identified here today, was in possession of 2 shotgun shells on March 24th of 2025. He admitted to having possession of them, one being in a bag that he removed from a vehicle that he was at during a traffic stop, and the other being on his person. The deputy testified that these were shotgun shells that were able to be fired out of a gun. They were not spent shells. As far as knowingly possessing them, the defendant admitted to the deputy that he was aware what these items were when he picked them up, assuming that picked them up out of the yard, like he said. We don't know how or why, but he did know that they were in fact shotgun shells. And being that he has not had his rights restored, to have ammunition or firearms. He is a prohibited person from having those. So we'd ask that the court find that this all happened here in the village of Centerville, County of St. Joseph, state of Michigan, and that we have properly identified the defendant as the person accused of the crime, and that it can be bound over to circuit court as charged.
Thank you, Mr. Truckee.
Thank you, Your Honor. Ask the court to consider the evidence presented today and the statements of the deputy regarding a traffic stop. He was surveilling Mr. Fuller because he was sure he was going to ride this motorcycle, and he better not. He was going to go wait for him. It's not bad police work if you think something's going to happen to get in a spot where you think it might pass by. Well, Mr. Fuller never did. He gets in the passenger seat of his girlfriend's father's car, who the deputy knew lived in the same house as Karan. I think, judging the deputy's statements and answering just about who lived where and when, I think Your Honor can use some of that dialogue to kind of judge that testimony. We have a traffic stop initiated because a vehicle piqued his interest, and I don't believe that is the standard. Vehicle piques one's interest. It's not close enough to see faces when the vehicle turns, or when he lays eyes on the vehicle. It just piqued his interest. I would suggest that we're here on an afternoon and there's a car driving around Karan's house when a deputy's looking for Karan to get in trouble. And I believe Karan does have standing to challenge the validity of the stop and the seizure of his person as part of this traffic stop. Ask the court to find that it was not based on reasonable suspicion and not bind over because the evidence ought to be suppressed. Thank you.
Your Honor, I would point out to the court that the deputy did testify that the reason for the traffic stop was an obstructed vision. So there was in fact a reasonable suspicion that there was a violation of the motor vehicle code. There's nothing improper as to what Deputy Van Dyken did that day, and the presence of the shotgun shells on the person of Mr. Fuller and his admissions, I believe, are sufficient for probable cause, and I would reserve on arguing any issues with a suppression motion until one is in fact filed and properly documented. Thank you.
Thank you. Well, this is a pretty straightforward case. It doesn't take too much reasonable suspicion to make a traffic stop. As it turns out, the driver had no license. Then it turned into something else when they found some controlled substances on him. But as the way I heard the testimony, the defendant got out of the car. And Deputy Raymond then had contact with him. Defendant opened his bag and Deputy Raymond could see a shotgun shell in there and took it out. Then Deputy Van Dyken comes over and says, well, I had this shell. So he talked to Karan and found the shotgun shell in his pocket. Same gauge, possibly the same make, but that's it, 2 shotgun shells. But the defendant is in a position where he is a convicted felon, and these are unspent shotgun shells. Now, granted, you wouldn't just throw those in a burn barrel or something, but nonetheless, the defendant knowingly had them in his possession. If there are suppression issues, they can certainly be taken up in circuit court, as Ms. Davis indicates, after a proper motion is filed. Because of the defendant's criminal history, the supplementation makes this much more serious than it would originally be on a 5-year felony offense. Anyway, I find there's probable cause to believe the defendant knowingly possessed some shotgun shells at that time and date, and I bind the matter over to circuit court. There is still the issue regarding the defendant's bond. His bond was $10,000 cash or surety. He missed a court date, which caused quite a bit of consternation. Then Ms. Davis requested that he test as his bond is ordered. That was a bit of a fiasco as well. He went to the center, day reporting center. We hadn't yet got word to the center. He left and we had trouble eventually. I understand he went in there and did test positive for one or more controlled substances. Laura, would you print out a bind over for me? Deborah, want to speak further to that bond?
Yes, Your Honor. I did receive an email from Melissa Bliss from Community Corrections today indicating that Mr. Fuller has been on pretrial supervision since March 19th, 2025 on his other two cases. He continued to call and check in weekly, informing of his new police contact. Or the last communication with him was on May 7th. He spoke with Mandy regarding his upcoming court hearings. And since that time, he had not made contact with their office and they had not been able to reach him at the number that they had on file. With that, Ms. Bliss is recommending that if Mr. Fuller continues with pretrial supervision, a GPS monitor is recommended. With that, I would also indicate to the courts my understanding from a review of the video from the St. Joseph County Sheriff's Office. It appears that Mr. Fuller, when he went to turn himself in on Tuesday, May, what's the 26th or 27th, whatever that Tuesday was, that he was only in the lobby for approximately less than 3 minutes. He had gone in to give his name and they were typing his name in to run him and he walked out. So I do have Sergeant Kyle Rice and Captain Troy Falk getting those videos. It's my understanding that was around 1:30, 1:40 in the afternoon. And then he did not, from the review of the court videos, come to the court on that date. He instead came to the court directly the next morning without going to the Sheriff's Department. So his indication at the last hearing that he spent 45 minutes waiting to get booked in and then walked here is, we believe it to be incorrect, false information. As far as the drug test, because of the most recent charge before this, where he was in possession of methamphetamine and a gun and running from the police, we had concerns about substance abuse. And that is why we asked the court to order him an immediate drug test. It's my understanding that from DRC, Mr. Fuller did appear. However, he walked out before they could even inquire as to what he was there for. He said he was there to drug test. They said, I don't have that. I don't have any information on that. And instead of waiting there, Mr. Fuller indicated that he must have been confused and he probably is supposed to go test at the courthouse, which obviously from the conversation on the record with the drug testing, he was well aware that he cannot test at the courthouse. He has to test at DRC. Then there was difficulty in getting in touch with him. I know from the information given, the court tried to contact him. Both of his current attorneys tried to contact him and he was not able to be contacted. He then went in to test, I believe it was 2 days later.
Well, his girlfriend was here on another traffic matter and I said, tell Karan he needs to get in there. So I think that's what finally precipitated the test.
At any rate, his test, the instant readback was positive for methamphetamine and amphetamines. It was sent to the lab, but it does take a few days to come back. So with all of that, there's also allegations that was sent up and then reviewing it of Mr. Fuller running from Three Rivers Police on the Monday before he tried to turn himself in. So there's certainly issues with his behavior, his use of substances for bond purposes and protection of society and making sure he's here and he's sober and coherent for the proceedings. We would ask that his bond be revoked and that he be remanded into custody. Bond for him has been set in each of these cases. He has posted bond, but he has not complied with the terms of it. He hasn't complied with the terms of his bonds in felony court that are already bound over, and it doesn't seem reasonable to think he's going to all of a sudden start complying with them now. So we would ask that the court consider canceling his bond in this matter Thank you.
Mr. Truckee, what's your thought?
Thank you, Your Honor. Well, we've got a report from Melissa Bliss about 2 files that aren't this one. And I don't know what the situation with that is. One condition here was to comply with pretrial services. I believe he's been reported, he's reported for a significant period of time. He's here today. He was here last week. The testing issue, Mr. Fuller, we've already gone over a lot of this, and I don't know if we need to go over all the previous stuff, but Mr. Fuller goes to the sheriff's department and then leaves. It's not enough to go turn yourself in. You got to wait in line to do it. The government wants Mr. Fuller. Mr. Fuller didn't ask to be arrested. So I don't know that you need to go to the sheriff's department to turn yourself in and then sit there and wait a particular number of minutes to make it acceptable. If he's so dangerous to society and he's got a warrant, grab him up, then figure it out. He comes here. I think this is a place he knows. And so he comes here to try to get things done. He goes to the DRC, and I think there was just some kind of paperwork issue where the request to test hadn't been processed through properly. So he shows up there. I say, we don't have anything for you. He leaves. I don't know if there's a prescribed amount of time you're supposed to wait at the DRC to drug test while you're on bond. He finally does get into the DRC to drug test, and what do? They put Duran's name on the form. Now, I don't know that there's any question as to who was there that day, but it's not just one more little black eye on this whole process. So I would state that Mr. Fuller is here today. He does have trial coming up. There have been some additional plea talks that have been put out there to settle all of this mess. So I'd ask that you just leave him on bond. If you want to put a GPS tether on him, that's understandable and justifiable, but allow him to remain on bond that he is posted and continue as he is not convicted of any crime at this point. Thank you.
Not clear of the status of the cases that were bound over. We'll look at that in a minute. But
I can give the court some update on that. So Mr. Gabriel has been handling the circuit court docket. There's a status conference in 2 days on 6/12, and he is set for trial, I believe, the second week of July. And his trial is the one that we are going to be trying first, which is the flee and elude, CCW, possession of methamphetamine, possession of firearm. So with that in mind, as the court knows, it is imperative that we have the defendant here and sober and prepared for a jury trial in circuit court or district court. And with his track record of not appearing and of using substances and of not complying with the pretrial supervision, I would ask that the court remand him into custody until such time as we can have the case tried. We took what the court said seriously as far as try a case, and we are ready, willing, and able to do so. So we'd ask that the court give us this motion to cancel his bond and make sure that he is going to be available. Thank you.
Let's look at recent history. 23147 FY and 148 FY are 23147 is RNC stolen property, possession of ammunition by a felon, 2 counts resisting and obstructing. That was bound over in 2023, 147, 148. 148 is unlawfully driving an automobile. Then 23550 is charged with carrying a concealed weapon and resisting obstructing. And for reasons I don't know here, that matter was dismissed by the prosecutor in June of 23. Then issues start now that the cases that are stacked up in circuit court. File 242019, I think is the case you're referring to. No, that one is charged receiving, concealing stolen property over $100 and resisting, obstructing a police officer. Now that is bound over to circuit court. The district court number is 242019. Posted a $15,000 cash or surety bond, and he failed to appear for his pre-exam conference on December 10th. And they then came in 2 days later. That occurred allegedly on November 14th of 2024. He's bound over to circuit court on a $15,000 cash or surety bond. The next case is 242020FY. That is charged with conspiracy to commit larceny, $20,000 or more, unlawfully driving a motor vehicle, and larceny of building. That matter has a $25,000 cash or surety bond. Again, defendant failed to appear on December 10th. Judge Pattison issued a bench warrant, and eventually he did show up a couple days later. So there are at least two cases certainly bound over to circuit court. Then there's the next one, which is earlier this year. That is 25454FY. I think that's the case Ms. Davis is referring to, as charged with possession of methamphetamine, carrying concealed weapon, possession of a firearm by an individual, possession of ammunition by an individual, and I think there's a felony firearm charge attached to that. That matter allegedly occurred on March 11th. He got arrested on April 2nd. So this case, that case had occurred March 11th. The warrant issued April 2nd. This case happened March 24th. So this was after the methamphetamine, carrying concealed weapon, possession of weapon by a felon. That one was a $15,000 cash or surety bond. So we got two $15,000 bonds and a $25,000 bond. Then this case, as I indicated, occurred March 24th. The charge was authorized on April 23rd, and he was arrested on May 11th. And it's a $10,000 cash or surety bond. So he's out on 4 substantial cash or surety bonds. He did the same thing in this case. He didn't show up on the day he was supposed to. He had been here in between the days. He presented himself at the court. Nowhere was there ever a motion in circuit court to revoke any of the earlier bonds for his subsequent arrests. But it takes a while to get a case through there. And in defense to Ms. Davis, she only took over 6 months ago. She's still working through previous administration docket. Anyway, then he dinks around showing up here. He gets Gary Gabriel in an uproar and creates some ill will that never needed to be created. Then he dinks around with the test. Then he tests positive for methamphetamine. So I'm going to cancel the bond, Mr. Fuller. You don't need to get any more trouble before they finally get one of these done. You can make a motion in circuit court regarding any or all of these bonds. Maybe there should have been a motion earlier, but there's only so much time in each day. Anyway, I moved to bind the matter over. The bond is canceled.
Thank you.
Which means this matter theoretically has to be tried within 21 days, 90 days. That's not likely. They've got some other cases that they could do, or perhaps everything can be worked out as a package deal. But you're going to go to jail. You won't get in any more trouble unless you do it at the jail between now and then. I think Ms. Davis expected you were going to test positive for methamphetamine, and you proved her right. All right, you can go with the officer, Mr. Fuller. Apparently your cases are fairly imminent in circuit court.
Your Honor, may I give my girlfriend the keys, please?
Yes, sir.
Thank you, sir.
All right, we'll stop the record and the live feed. We'll take a short break and then we'll be ready for the prelim on Matthew Tyler. Good morning, sir. Are you Christopher Sears?
Yes, I am.
What's the matter?
I said, yes, I am.
Okay, very good. Thank you. I'm Judge Middleton, and your lawyer, Rhonda Ives, is here with me. We've also got a visitor who's here, wanting to observe the proceedings. Mr. Sears, you were arrested on May 29th in Sturgis on a charge of possession of methamphetamine and maintaining a drug house. This was that house on Rose Street where a number of people got arrested at the same time. Ms. Ives, your attorney, tells me that you have waived your right to have a preliminary examination in this matter. The matter will be set for further proceedings in the circuit court. Is that correct?
Yes, Your Honor.
Where is the waiver?
Not yet.
All right, Mr. Robert has it. Is that true, Mr. Sears? You waived your right to have a preliminary examination? Mr. Sears, is that correct?
What does a waiver mean? I don't understand that.
All right, may I have it, Mr. Robert?
It's the document we went over this morning.
All right, well, let me go over it with him.
Okay.
Because it sometimes is confusing. All right. You're charged with a serious felony offense, possession of methamphetamine and maintaining a drug house. That's punishable by up to 10 years imprisonment and a fine of up to $15,000. The other is punishable by up to 2 years in jail and some sort of fine. I don't remember, $2,500, I think. Those are felonies. And when you're charged with a felony, you have the right to have a preliminary examination where it must be established that there's probable cause to believe that a crime was committed and probable cause that you did it. Now, probable cause standard isn't that hard to make, but you have a right to have that hearing. You met with Miss Ives at the jail, and she says that she went through this with you. So let me go through with you again. I, Christopher John Sears, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to afford one, but we have appointed Miss Ives to represent you. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with the crime. I voluntarily waive my right to a preliminary examination and understand that I will be bound over to the circuit court in the complaint and warrant. So you sign that, Chris Sears. Now, once I sign it, I lose jurisdiction over this matter and it will go to the circuit court and be in front of Judge Stutzman. Ms. Ives wants to make an argument regarding your bond, which is currently set at $2,500 cash or surety. But first of all, do you agree to waive the preliminary examination and have the matter bound over to circuit court?
What about that 7411 that my lawyer was talking to me about?
Say that again. I didn't get it.
What about that 7411 that my attorney was talking to me about?
Well, I think you already had a 7411 a couple of years ago, if I recall. You only get that deal once.
I'm not familiar. He didn't mention that he received a 7411. What we discussed was the current offer that the prosecutor would be willing to dismiss count 2, that they have no objection to a 7411. And so at that point, after we went over that offer, we agreed that holding the exam next week would serve no purpose and we would waive to the circuit court and that I would address bond today. And that's where we had left it.
So I can't get like a PR bond?
We're gonna talk about that in a minute. You
Okay.
had a 7411, file 212538FY. You were charged with felony possession of methamphetamine and a retail fraud. You pled guilty to use of methamphetamine and retail fraud. I gave you 3 days in jail and I put you on a 7411 probation, which to your credit, you completed. You got a successful discharge from probation in January of 2023. You called and gave us a new address. You paid all your fines and costs. You're not eligible for 7411 probation. 7411 probation is a kind of probation under the public health code that will allow you to have the charge taken off your record as a public record of conviction. And you've already had that. I don't think. There's more than one Christopher Sears. You're Christopher J. Sears.
Yes.
You also had a 7411 on a marijuana charge in 2006. So maybe that's why they didn't show. But yeah, you've had one or at least one 7411. All right. So first question. Do you wish to waive the preliminary examination or have this matter set for a hearing next week?
What do you think would be best for me? I'm asking my attorney.
Okay.
If he needs to talk to an attorney, I'd ask that they do it in private.
Yeah, obviously, we're not gonna do that here. So we're not all on the same page. So I'm sure not ready to make a decision regarding your PR bond.
But if I have to, I'll waive it. I need that PR bond.
I'm not bargaining with you for a waiver for a PR bond. Your bond is relatively low, $2,500 cash or surety, and nobody's willing to put up $250 to get you out of jail. I'm also concerned that when you get out of jail, you go back to this flop house at 113 Rose Street, where Mama D, Danette Carter, is living right now. So I'm gonna just leave this on for a prelim for next Thursday. Unclear whether he wishes to waive or not. Rhonda, I'm gonna give this back to you. And I'm not bargaining him for a waiver for a PR bond. All right, Mr. Sears, Ms. Ives will be out to the jail to see you. It just popped up. Yeah, they got him in one of the other rooms. All right, thanks. All right, bye-bye. Go ahead, sir, have a seat. We have to turn the sound on in there.
Hello?
There we go. Good morning, sir. Are you William Raymond Duzinkus?
Yes.
Is that how you say it?
Yes, Zinskis or doesn't.
All right. Well, the file number here is 25960. You're charged with 2 counts of resisting, obstructing a police officer and disturbing the peace. Those first 2 are felonies punishable by up to 2 years imprisonment and a fine of up to $2,000. The last count, disturbing the peace, is a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. The prosecutor has agreed to dismiss all of those charges if you plead to attempting to resist, obstruct a police officer, which is a misdemeanor.
Yes.
That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. Let's take a look at your complaint here. This happened 16 days ago on May 25th. It's alleged you did assault, batter, wound, resist, oppose, or endanger Sergeant Aaron Moore and Officer Joshua Wired of the Sturgis Police Department. This happened at some stores in Sturgis. Do you understand the charge?
Yes, Your Honor, I do.
Are you gonna plead to that lesser misdemeanor charge of attempting to resist or obstruct a police officer?
Yes, Your Honor.
All right, well, let me tell you this. Couple things that you need to know. If you do plead guilty to a felony charge, you give up your right to have a trial in front of a judge or a jury. There will not be a trial. Do you understand that?
Yes, Your Honor.
If you had a trial, you'd have the right to be represented by an attorney. Mr. Gibson is here with me in the courtroom. Could also hire an attorney of your own choosing if you wished. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court, so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf. But you don't have to, because you have a right not to testify, and if you did not wish to testify, the judge or jury could not hold your silence against you. And you have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You understand all that?
Yes, I do, Your Honor.
All right. Now, other than this plea agreement where they're dismissing these felonies for the plea to the misdemeanor, did anybody promise you anything to get you to plead to this
No, Your Honor.
or threaten you?
No, Your Honor.
Now, you were in Sturgis on this night, which is May 25th. Had you been drinking?
No, I don't drink and I don't eat drugs, Your Honor.
All right, well, it says here you look like you were on the way from Minnesota to Ohio, just passing through here. Is that correct?
Yes, I walked, may I speak? Is it okay, Your Honor?
Yeah, go ahead. Tell me what happened.
I left Minnesota about 128 days before this because it wasn't working out to get my ID. And I had to fall out with a friend. And so I walked through Wisconsin up to the Upper Peninsula, down to my non-extraditable in Indiana. The whole mission was so I could get.
That's a long way from there to here. You walked all that way?
Yes, sir. I mean, I've had rides from troopers and, law enforcement and some good people. I was just attempting to find an address for people I knew down in Kalamazoo, and it didn't work out. So I went into Michigan City and got my ID, and I just want to get back to work. So I was walking through Sturgis to get to Coldwater. So my friend Joey from Indiana, Fort Wayne, would come and meet me with my hard copy so I could get my ID and get, glasses and Medicare and stuff.
Well, here's what it says. You had a black Dude Abides t-shirt, dreads. You're in a store and they called and said, hey, this guy's threatening us. So they came and you kicked the entry door open and you were spitting on cars and knocking trash cans over. What were you upset about?
People were behind me, I get nervous or anxious. And then so then my reality, I get blurred, but I turned around and I said I had PTSD. I looked at the counter, I was explaining to them that I didn't mean none of this, that I deal with schizophrenia and PTSD, and I just wanted some cigarettes. And I picked up the trash can too, man. I know they don't have that in the report, but I picked up the trash can. And I can't explain, I don't understand why it wasn't sitting or following commands by the same people I honor, man. So
all right, so then you kind of struggle with the cops and then they tased you a couple times. That probably wasn't fun. And then they took you to jail, correct?
Yes, sir. Yes, Your Honor.
All right. Mr. O'Bear, anything else you think I should know?
No.
You must be in awful good shape if you can walk from Minnesota through the UP to Sturgis. I just finished a book that was set in the Upper Peninsula in January. So you were walking through the UP like in the winter time?
Oh, yes. I got caught in an ice storm a couple times. I made it though. I got down to Kalamazoo and the person I knew, I guess I didn't know him that good because I only spent a night on their couch. He wound up swinging on me and I left a bunch of stuff in his house that got stolen from me once he locked the door. I didn't hurt him or anything. I just didn't want to be hurt. I went back up to Marquette with somebody I met. She wanted out to be bat crazy. And so I just said, I'm gonna go down into Indiana myself and get my ID so I can get to work. That's all this has been about.
What is for you in Ohio?
Just a new beginning, I guess, somewhere where.
I encourage that. I'm gonna give you 0 fine, $75 crime victims' rights fee, and a $50 state minimum fee. You were a huge pain in the neck and scared the people in Sturgis. I'm gonna order 30 days jail, credit 16, 14 days to do, $125 or 2 additional days. There's 5 days a month added to that as good time or reduced from that. You got about 8 or 9 days to do here, and then when you're released, you should be free to go on about your business. So good luck, sir.
Are you asking for restitution in that one, Josh, though, for the
Thank you, guys.
No, I'm not gonna order any restitution. Simply, hello, Deputy Ross, how's it going over there?
So good.
All right, good luck, sir. We've had that guy.
Yeah, I think I've seen it. I recognize.
No, somebody passing through with difficulties, struggles, PTSD, mental health issues since I started in 1980. Somebody's just on their way from point A to point B, and the problems seem to be right along with them.